Here's a quick question for you sports fans out there. Have you ever watched a game of rugby union and then switched over to rugby league? At first glance, they look almost identical. Oval ball, 8 shaped goals, backwards passing, and plenty of tackling. But as any fan will tell you, the rules are actually very different, from the number of players on the pitch to how you score points. Hello, I'm Peter Brash from Murray Claims at Grigor and Young in Elgin. Now imagine if a referee in rugby union match suddenly started applying rugby league rules. It would be confusing, it would be unfair, and it would probably be a bit of a disaster. Well, believe it or not, we're seeing something what I think is very similar right now in the world of personal injury law, and that's I would say a worrying trend that we have noticed, whereby English insurance companies are trying to apply English rules to Scottish personal injury claims. You see, while the basic law of negligence is pretty much the same across the UK, the way that we value claims, which we call quantum, can be worlds apart. For example, did you know that in Scotland we don't use the English tariff system for whiplash injuries to the neck and back? That usually means higher average awards in Scotland. Or take services claims. That's compensation for when family members help you with things like getting washed or dressed, or cleaning or cooking after an accident. In Scotland, our laws are based on legislation and are much more pragmatic and fair, whereas in England there are strict thresholds that just don't apply here. We recently dealt with a case where an insurer admitted 100% liability for an accident but then refused to make any offer for services. And the reason for that was because they were applying English standards to a claim which should have had Scots law applied to it. The kind of negotiation we had in that situation felt less like a legal argument and more like bullying against us. So the article that is accompanying this video covers some of these issues in a bit more detail. We break down the specific ways that Scots law protects you better than English law. We give a real life case study involving a car passenger from a case in Elgin where this exact issue came up, and then most importantly we talk about the steps that we're trying to take to minimise the risk that we'll be facing this kind of argument in lots of cases in the future, but given that insurance companies are basically based in England. If you've been injured and the insurer is acting like they hold all the cards, then you need to understand and if necessary act upon and challenge them about which rulebook they're actually playing by.